All right, welcome everyone. We're going to go ahead and get started today with our first webinar of the year here at Sanderson Firm. So happy New Year. I think it's about time to stop saying that as we round out January. I'm excited to be emceeing today. Today's webinar will be Medicare Secondary Payer Initiatives in 2026, What's on the Horizon? I have Brendan D'Souza, our Chief Legal Officer with me, and Kayla Pigeon. Brendan, do you want to, she's our VP of MSP Compliance. Brendan, do you want to introduce yourself and then kick it over to Kayla?
Yeah, sure. Hey, everyone. Great to be here today. My name is Brendan D'Souza. As Amy just mentioned, the CLO of Sanderson Firm. Hopefully everyone's staying as warm as possible out there. I was just talking to Annie and Kayla a little bit offline that I got a freeze warning. It is 52 degrees in sunny Florida right now, and apparently that's enough for a freeze warning. So hopefully for those who are actually freezing, hopefully you're staying warm. But a little bit about me, I've been in the space since 2017, where, as Annie likes to say, I cut my teeth on all things Medicare secondary payer. I worked at a large national provider of Medicare secondary payer services, so sort of cut my teeth on the conditional payments, Medicare reporting, MSAs, all that fun stuff, but just happy to be here for the first webinar of 2026.
Hi, everyone. My name is Kayla Pigeon, VP of MSP Compliance here at Sanderson Firm. It's actually cold here up in New Hampshire. We're dealing with about a couple feet of snow and about 5 degrees, so a little bit colder than Brendan's 52. But a little bit about me. One of the attorneys here at Sanderson Firm. I started at a large carrier. I like to say I grew up Medicare compliance, basically, right out of my undergrad. That's what I basically started doing and have been doing ever since. So, yeah, happy to be here.
Awesome. Okay, so
Awesome.
a little bit about us. So Sanderson Firm, for those who may not be aware, so we are a law firm, right? We specialize in Medicare secondary payer services. So this is what we do exclusively, right? Proud to be a woman-owned business. We have a national footprint. We have clients across the country, insurance carriers, large and small, self-insured employers, TPAs, governmental agencies, you name it. We're comprised of not only our legal team is actually being outnumbered here, a team of legal, clinical, and claims professionals. And yeah, as of most recently, our team just dinged over 70 total employees. So a huge thank you to all of our clients and supporters who have made the growth possible. Okay, all right. So agenda for today. So we're gonna get right into it, right? Because there's lots to cover, a lot of things going on. We're gonna start with CMS's January 15th, 2026 webinar. As most of you remember, right, the Trump administration assumed office, right, in like what was this, early 2025. After that, there was a partial communications freeze, so CMS wasn't able to have a webinar. Then there was a government shutdown towards the end of last year, so there was still no CMS webinar. So really the webinar from a few weeks ago, CMS sort of first reopening into being public facing, which comes at a really good time, right? Because as we'll cover later, civil money penalties are coming out. So we'll talk about what CMS talked about on that webinar. We'll then hop into the NGHP user guide and sort of what changed there. Then we'll move into predictions for 2026. Okay, so recap from CMS's most recent webinar. So this is one of the more important, well, everything's important, but one of the more important things that they talked about is, here's the deal, right? On CMPs, if you receive notice of a civil money penalty, right, that you are late in reporting your TPOC or your ORM, all civil money penalty correspondence is only going to two people. It's going to your assigned account representative, your AR, and your assigned account manager, your AM, right? So your account representative is someone who has legal authority to bind the company to a contract. Typically, that's going to be the responsible reporting entity's CEO, their president or VP, their CFOs, or some other high-level C-suite level office, right? And it's also going to the AM. The AM is someone who doesn't have to be in the C-suite. It really can be anyone in the organization. But the AR and the AM have to be different people. So correspondence is only going to those two individuals. Um, uh, so if you're, a client of ours or for Section 111 agent reporting purposes, or use some other vendor or law firm to be your Section 111 reporting agent, keep in mind, like your Section 111 reporting agent is not going to be receiving notice of these civil money penalties directly. They're not going to be made aware at all unless your organization, your AR, your AM forwards a copy of that communication to your actual reporting agent. So that's something to keep in mind. If right, you want to evaluate whether your AR and AM are hip to what's going on, they should just be notified that, hey, to the extent that you receive correspondence from CMS regarding a CMP or really anything really, don't just assume that this is going to be handled automatically for you, because if it's not handled and that civil money penalty correspondence goes unanswered, right? After 30 days, CMS will issue its sort of final notice, where your organization will be subject to tens of thousands or maybe hundreds of thousands in civil money penalties without an opportunity for appeal because the deadline was just completely missed. So you want to make sure that your ARs and AMs are aware of what's going on.
All right. So, as a reminder, right, CMS is anticipating that they're going to be completing their first round of these audits for the civil money penalties in February of 2026. So that is just, next month. So we're coming up on that. They're going to audit 250 records, and that's going to be across both NGHP, so non-group health plan, and group health plan entities. And ultimately, this means that the earliest time we're thinking that we might start seeing these actual letters going out is going to be in March of 2026, right? So we're getting really close to that starting to happen. A few things of note that they said on the webinar that I think are important to point out, or I think people will be interested in. One, they did tell us that they are planning on publishing statistics regarding the civil money penalty enforcement. We don't know exactly what that's going to look like, right? But I think we're all going to be very interested to see probably something like what's the average amount of civil money penalty they're actually levying, how much they're actually going to be recovering in CMPs. I know a lot of folks are interested in also the sort of ratio, right? So we know that they're going to be auditing a ratio of files across NGHP and GHP. I think a lot of us are interested to see what that looks like, how many files are actually being audited in the NGHP world, as we continue to assess what's the true exposure for these civil money penalties and what this all really looks like. Adjustments for inflation are also something that they addressed. I think this is a really important area as far as people probably having questions about what this looks like. We know that it's going to be locked in based on the date of the audit. So essentially, this means that if they audited a file in February, right, and then they send the letter out, basically that first notice, maybe you send in mitigating evidence, maybe they disagree, and we get down the line, maybe we're appealing a CMP. Whenever we get to the point of them actually sending a civil money penalty amount to you, the inflation amount is going to be adjusted as for what the inflation would have been the date that they actually audited that file. So this means essentially that we're not going to get penalized for entering into that appeals process, right? So right now we know the inflation is sitting around somewhere around $1,400 per day per claim for the CMP amount. Let's say between now and when I finally got my finalized civil money penalty amount, the inflation rose quite a bit. I'm not going to be having to pay that higher amount. I'm going to pay whatever it was at the time that the initial audit was done. So I think that's a great thing that came out of the webinar as far as making sure that we know that we can be entering this process and not potentially being held responsible for higher inflation amounts on what these penalties might be.
Okay, so probably the biggest thing we learned, and this was kind of groundbreaking news when CMS said it or released it on their webinar, was a delay in civil money penalties. So CMS said that it will delay civil money penalties for all workers' compensation records until July of 2026. So as most of you are aware, right, back in April 4th, of 2025, right, there was an update to workers' compensation MSA reporting where if you settled any workers' compensation claim involving a Medicare beneficiary, then as part of your TPOC reporting, you had to upload 7 new pieces of information in a workers' compensation Medicare set aside field, right? So that was new. CMS says as a result of that being new and as a result of quote unquote April 4th, 2025 workers' compensation reporting issues, CMS would be delaying CMPs for all workers' compensation records until July of 2026. It was a little unclear to me or to us generally about, what exactly did records mean, right? Was that just the TPOC record, or did that also include the ORM record as well? It sort of made sense that that would only be applicable to workers' compensation TPOCs because work comp reporting is only work comp MSA reporting is a subcategory of TPOC, right? So there was literally no change to ORM reporting at all. But CMS says basically sort of gifted the entire industry a gift, and they said, hey, look, regardless of whether it's ORM or TPOC on your workers' comp file, all CMPs for all of your work comp records are being delayed until July of 2026. And I will let Kayla get into some examples of what this actually looks like in practice.
Well, can I jump in for a second? I just want to
Yeah.
clarify a couple things. I know we said we would take questions at the end, but there's some questions. It is in your annual profile report. So there's been questions, account rep and account manager are listed on the annual profile report. That needs to be done. So if you need to update those, that is exactly what you would be looking to do. And then one other question was about GHP to NGHP files. They're selecting them randomly. It will be proportional to what's submitted, but they are going to be selected randomly. I just completed a year of being president of the MSPN, the National Medicare Secondary Payer Network, and we met with them periodically. And with our last meeting late last year, they had run a couple of kind of tests to kind of see what it was looking like. They were using random selection, and then the NGHP side of the house, it looked like things were coming out pretty good. So there wouldn't, hopefully be a lot of penalty opportunities. But again, we, keep throwing questions in the chat. If we can answer them as we go, we may, but otherwise we'll answer them at the end. All right, back to you, Kayla.
Right. All right. So as Brendan talked about, there was some, after the webinar, I think people had questions around what this delay truly meant or what it really looked like in practice. So we did actually reach out and talk to CMS a little bit about like what the actual applicability of the delay was. So we have a couple examples here to provide you of what this delay is going to look like in practice. So and these can really be, both examples are talking about settlement, but they could be swapped out for an ORM situation. So in the example 1, if we have a workers' compensation claim and it's settled on June 15th of 2025, and it is not reported until November 2026, is that report going to be subject to CMPs? So even though in the situation, we do have a case where that report, that TPOC report is happening over a year later, because that TPOC report date is happening before July 2025, it's not going to be subject to penalties. So this is essentially how it's going to be operating. So everyone's been talking about October and October being that date. We have this little delay here, essentially where it's now going to be pushed to July. And this is how it's operating. In example 2, we have a workers' compensation claim that settled on August 11th of 2025, and it isn't reported until September 2026. This claim is going to be subject to potential civil money penalties because it occurred after that July 2025 date, and it was reported more than a year after the settlement. So this will hopefully give you all an idea of what this is going to look like. It really is a true delay. And then as far as the timing, how they came to this idea of July 2025 being the delay. They are citing, and if you look at sort of what was given to us for materials for civil money penalties, they talked about if there were ever going to be updates to processes or updates that were going to require system updates, they were going to need to give us a minimum amount of time to adjust. And they're essentially saying this is that 6-month adjustment time from when they told us that work comp reporting was going to be coming out. So, yep, it is going to be a year from that July 2025 date. So at that point, we're going to have July of 2026. I think I saw a clarifying question about that. So yes, anything after July 1 of 2025.
Okay. So the other update, or I would say point of clarification that CMS gave, this is huge, right? If you haven't had this question, we get this question a lot, and if you haven't had this question come up yet, this is probably bound to come up for you at some point. So sort of to level set, this is about the safe harbor exemption, right? So in order to determine whether someone is a Medicare beneficiary, you have to obtain it's known as their Big Five information: their first name, their last name, their date of birth, their gender, and either their social security number, their HICA number, or their Medicare beneficiary identifier. And CMS, in their infinite wisdom, recognized that, hey, it's not always possible for responsible reporting entities to obtain these Big Five data points in order to determine whether that person is actually a Medicare beneficiary in the first place, and therefore whether the responsible reporting entity is subject to the mandatory insurer reporting obligations. So CMS in the final rule, in the text of the final rule itself and in the regs, basically says, hey, look, if you reach out to the claimant/plaintiff and their attorney, you have to make a total of 3 reach out attempts. 2 of them have to be made by mail or email, and the third attempt can be made, or the other attempt can be made by telephone or some other reasonable method. If you reach out and there's no response at all, well, then you're good to go. The parties weren't willing to cooperate. Save those reach out attempts to your file, and CMS can't then later come after you for a civil money penalty for you not having reported because you were simply unable to obtain the information. There is also a little exception where, like, let's say during one of the reach out attempts, during number 1 or 2, the attorney comes back to you and says, hey, we understand this section 111 reporting, but we are, clearly unequivocally, declining to provide you with this information. That works as well as 2. That satisfies the safe harbor, and you don't have to continue to reach out for the Big Five information. But the issue in this comes up because, right, the final rule and the reg states you have to reach out to the attorney and the operative word is and the claimant or the plaintiff, right? And a lot of us know this is not just limited to MSP. This is just claims and just the legal practice generally, right? If someone has an attorney, right, that attorney there's a letter of rep, right, you're receiving a letter from the attorney saying, hey, I'm representing this person, and please direct all communication through me. If it relates to the case, contact me, don't contact my client. That's just how it is, right, in practice. You've also got ethics opinions, state bar ethics. Sure, there's case law on it, state laws, sort of supporting this idea, where CMS came on the webinar and they said, hey, look, all that stuff is cool, but those ethics, those obligations don't apply. You're reaching out for their first name, last name, date of birth, social, all this stuff in order to comply with federal law, right? So it should not be a concern. So CMS gave an example, right? CMS says, okay, let's say you're an RRE and you're missing the social security number for an injured claimant, right? So you don't have the SSN, so you can't query whether that person is a Medicare Benny, right? So what do? You contact the injured person's attorney. Let's say you do it perfectly, right? You do it twice by mail. You don't receive a response. You then contact the same attorney by telephone. You don't receive a response. If you as the RRE think that that's sufficient and you've satisfied your good faith attempts and that you would then be exempt from civil money penalties if it turns out that this individual was in fact a Medicare beneficiary at a later date. You would be incorrect, right? Like that's not enough. CMS says, hey, look, if you reached out to the attorney and received absolutely nothing, then it is then incumbent on you. CMS expects you to then reach out to the injured individual directly. And presumably you'd have to reach out to that person, 3 times, right? And again, twice by mail and another time by phone. So CMS, thankfully, I guess I guess you'd call it a bit of a workaround where if you as an RE are still concerned about state law or just ethical concerns about reaching out to an individual directly rather than through their attorney, you can still maintain your current process of just reaching out to the attorney for that information. And if you get lucky, if the attorney confirms and responds and says clearly like, hey, look, I'm not going to give you this information, then according to CMS and what they said verbally is that satisfies the good faith harbor exemption, and then you don't have to reach out to the claimant directly another 3 times, right? So yeah, if anyone has any questions on this, please feel free to let me know in the chat, and hopefully I explained that clearly.
All right, so they went over again as well just what this letter process is going to look like as far as getting the actual notice of the civil money penalty. And we sort of outline a base idea of what this might look like here. So the first letter you're going to get if you are the very lucky RRE to be selected and potentially have that civil money penalty is going to be an informal notice, an intention to impose a civil money penalty. Again, we're kind of harping on this, but it's going to be your account representative and your account manager. And those are the people that are going to receive that correspondence by mail. We've had a couple questions here about whether or not go paperless figures into that, as far as we're not under any understanding that this is going to be happening anyway other than a physical letter. They're going to include the basis of that determination and basically a summary of the non-compliant record. So whether it's an ORM record, ongoing responsibility for medical record, or that total payment obligation to claimant TPOC record, you're going to get a summary of what the record is that we're determining is potentially eligible for that civil money penalty. And then you're going to have instructions on how you're going to submit your dispute. You're going to have 30 days to submit that mitigating evidence. Again, mitigating evidence has not been defined, which is great for us. It means we can be creative in responding back and saying, these are the reasons why we shouldn't have a civil money penalty in this instance. Letter number 2 is going to be different depending on whether or not you were successful or unsuccessful, or whether you responded at all to that initial notice, right? So the first option for letter number 2 is going to be if we're unsuccessful or we didn't send anything in response. So they disagreed with our mitigating evidence. And that's going to be the notice of proposed determination to impose a civil money penalty. Again, it's going to tell you your argument for appeal failed. And it's going to include information about the appeal rights and instructions. And again, I believe in this letter, it's going to include the proposed actual civil money penalty that would apply. So you're going to start seeing the numbers on there. If you were successful, you sent your mitigating evidence and they agreed, then the decision regarding mitigating evidence approval letter is going to be sent. And it's basically going to say, we agree with you, a civil money penalty is not going to be imposed in this instance, and no additional action is required. So you might see that a lot of this gets resolved in that 30-day period. I think obviously we don't know exactly what this dispute and appeal process is going to look like, or truly the effectiveness of different arguments, but our assumption would be that this is going to feel very similar to the conditional payment space, in that a lot of this is going to be resolved in these initial disputes, either in that initial dispute where we're saying, here's our mitigating evidence, or in that first level appeal where we're doing the administrative law judge appeal. Not expecting, similarly to conditional payments, us to have to go into those higher levels of appeal on these.
And the third, or depending on how many appeals were filed, the last letter that you will receive from CMS on this is going to be titled Notice of Final Determination to Impose a Civil Money Penalty. So you get this because all of your appeals were completely exhausted or simply no appeal was filed. And really quickly too, since I'm not sure if we mentioned this already, so there's going to be three levels of appeal, right? So you first receive that first initial notice, right, which you can respond to, right? Your first appeal would be with an administrative law judge, an ALJ. That's going to be a hearing on the records with a judge, most likely telephonic hearing if it sort of operates as anything like how conditional payments operate. And technically, you won't need an attorney to sort of represent you at these hearings, but considering the amounts involved can be anywhere from tens of thousands to hundreds of thousands of dollars, might make sense to have an attorney handle the file for you at that stage and forward. So, right, first level is ALJ. The next one, if you're unsuccessful and you can appeal, would be a level 2 DAB, Department Appeals Board. And then the only other opportunity for appeal would be judicial review. Judicial review, that would be in federal court. So, assuming you exhaust all of those, right, and you're not successful, you're going to receive a notice of final determination to oppose a CMP. It's going to be final. CMS says that payment is going to be due within 60 days, and this must be made electronically on pay.gov. So this is somewhat new, right? So earlier last year, there was an executive order which was signed, which effectively requires all payments made to the federal government to be made electronically. There are some exceptions for that. There's an undue burden sort of exemption, but typically if you're in an RRE and you have the ability to make payment electronically, you're not going to qualify for an exception, so you're going to have to make payment on that website.
All right, so talking a little bit about what we're expecting to see in 2026, and then specifically as it pertains to the civil money penalties, right? So based on all of this, we're expecting to see that CMS does move forward with their audit of the 250 records, and that's going to be split between the non-group health plans and group health plans. Again, to the extent that they're looking at group health plans now, we're going to be seeing them look at those liability records, those liability TPOC records, and not the workers' compensation ORM and TPOC records that we're looking at on the delay. But we'll see it happen as the year goes on. Also, this next sort of note isn't necessarily for 2026, but just kind of a note in general about civil money penalties. This is the first go around, right? This is the first iteration of what civil money penalties is going to look like for everyone. So we're imagining a lot of this will change along the way. We're certainly going to learn a lot as the first ones come out. And it's possible that in the future, CMS makes changes to what this looks like or what they're looking at. We know that they right now are just looking at things like timeliness of reporting, but that doesn't necessarily have to be set in stone. They could continue to put us on notice that other things are going to be included as we move through this process. So this is round one, but we're expecting, versions 2 and 3 at some point. Maybe not in 2026, but as we continue to move through the civil money penalty journey that we're all on here. And then also just a quick note, we will be, Sanderson Firm will be standing at the ready to assist you all to the extent that your company does get one of these letters and requires assistance in doing that dispute or appeal. So we'll be ready to begin doing that in March, should anyone require us to step in, and that will be something that our legal team here at Sanderson Firm will be handling.
Okay, so there's a little bit of a recap, and there's a reason why we put this slide on here. But just to recap, right, civil money penalties, just to make sure everyone is on the right page, right? Final rule went into effect or became applicable October 11th of 2024. So that means for any, for right now, right, for any liability or no fault claim with the late reported TPOC or ORM, right? That if it takes you longer than 1 year to report, then you're subject to CMPs. We've talked about early how there's been a delay for work comp TPOCs and ORMs where nothing will happen on those until July of 2026. But the sort of the questions we get on this kind of get to the tiers, and I'm consulting my notes here. I don't want to get it wrong. So okay, so one of the questions is okay, well, like when if you the RRE are late, when do the penalties start accruing? So let's say you're an entity where you had to report by the 365th day. Let's say you didn't report until day 375, right? So you look at the tiers, you say, okay, it's been reported after 1 year, but it's been it was at least reported within a period of 2 years. So tier one, $250 in civil money penalties applies per day. Okay, this does not mean that from day 0 to day 375 that every day is $250 per day. It's not what that means, right? You are non-compliant as of the 366th day. The date after the 1 year, because during the 1 year you have a grace period, right? As soon as you're late by that 1 year, 1 day, that's when it starts, and that's when they start accruing. So for that example, you'd have a civil money penalty assessed against you for $250 times whatever the 9 or 10 days that is. The other question that comes up a lot is, okay, is there going to be maybe a blending of these amounts? So let's say there's an RE and it takes them longer than 2 years to report, but they at least report within 3 years. So the question is, okay, in that after 1 year but within 2 years, are those days penalized at $250? Then the days after the 2 years, are those dates penalized at $500? Right? Is there a blending going on? CMS actually has never confirmed this. It's an interesting question. They haven't confirmed this in writing or at least verbally to my knowledge. I would just assume that CMS would apply the simplest approach possible and just apply the sort of the maximum penalty that applies. So in the example that I gave, CMS would say, okay, you're more than 2 years late, but less than 3 years, all of the days that you're late after your initial 1 year, we're going to penalize you at $500 per day. That's why I think CMS is going to apply this. But hey, the beauty is we will all very soon find out whether my interpretation is correct or incorrect.
All right, so a couple more reminders about whether and in what instances civil money penalties are going to apply. You've heard this term record coming up a lot, right? That's the CMS even using the term record is sort of what clued us into the fact that they weren't just talking about workers' compensation TPOCs, but also ORM in terms of what they were going to be putting delays on for the civil money penalties. So it's important to understand that for compliance purposes, a record is going to be defined as any individual occurrence of a TPOC or an ORM. So if I have an open accepted workers' compensation claim where I'm reporting ongoing responsibility for medical, and then I, down the line settle that claim and I file that total payment obligation to claimant, that TPOC, those are considered two separate records in terms of Section 11 reporting and in terms of how the civil money penalties work. So if we have a situation where we are reporting both that TPOC and that ORM, that's going to be two records. And that means those two records could technically both at different points in time be eligible for a civil money penalty. So if through their randomized process, that claim is just extra lucky and it gets picked both for its ORM record and its TPOC record, those could both be separately looked at in terms of civil money penalties. I think this is also where sort of the terminology that's been used as far as up to $1,000 per day per claim, it's really more up to $1,000 per day per record. That you're looking at. A couple important things I think to clarify here, though, is these would truly have to be selected randomly separately. One of the things that CMS has very explicitly said to us is they're not going to look at, for example, the TPOC record on that file determine there's a civil money penalty, and then dig around, look at the ORM record, and also determine if that is going to be eligible for a civil money penalty. So it's not going to be a situation where the TPOC record gets identified to be reviewed. They audit it, find a problem, and then start reviewing the other records for that individual claim. It's truly going to be something that's going to be randomized. So the odds of this, I think when we talk about the grand scheme of things and the idea of, they're going to be looking at 250 records across all RREs and across NGHP and GHP quarterly. I mean, buy a lottery ticket if this happens to you, I guess, because you're really extra lucky in that scenario. So unlikely, but theoretically possible.
They should purchase a lottery ticket. It might help. It might help pay for the CMP.
Yeah, right. That's how you should fund that CMP for sure.
Yeah. So more hot takes, more predictions for 2026. So yeah, we predict increased denial of benefits for workers' compensation Medicare set-asides involving Medicare beneficiaries that don't have an MSA. So again, I mean, we keep beating a dead horse here, but this has been a thing since early last year, right? If you have a workers' compensation claim involving a Medicare beneficiary, you've got to report Medicare set-aside information to CMS. Doesn't matter if it doesn't matter if that claim was denied. Doesn't matter if if the claim is settling for under $25,000. Doesn't matter if you have a statement signed by that person's treating physician saying that Sally Mae is a-okay, she doesn't need any medical care at all. Doesn't matter if you have a court order signed by a judge saying, yep, the self-insured employer, they're not responsible for any future medicals. None of the facts matter. CMS just wants to have some information reported to them. And so if you find yourself in a comp claim involving a Medicare beneficiary and you don't have a Medicare set aside, you just want to make sure that your position is defensible, right? Either legally and or medically, because what's going to happen is CMS is receiving all of this data now for the first time ever, and they're gonna see, Sally Mae, she's got a $50,000 TPOC, $50,000 settlement, and we see that zeros have been populated in the Medicare set aside field, so Medicare knows that there was no MSA. Well, guess what? CMS reserves the right to audit that file and potentially deny benefits to that Medicare beneficiary. So, you don't want to put yourself in a scenario where a Medicare beneficiary is, having coordination of benefits issues, or their benefits are being denied or have been suspended as a result of, you settling the claim and not having taken Medicare's interest into account with an MSA. So um, a point of note here, I have at least heard or seen situations where there's just been an arbitrary number sort of plucked out. So the claim is settling for, I don't know, $30,000, and the attorneys are really anxious. They've got an agreement in principle. It's got to settle today, right? You don't have time for an MSA. We can't get the records. It's too much. Let's just say out of the 30K, let's just say $7,000. That sounds about right for a Medicare set aside amount. Please don't do that, right? Because if you do that and CMS audits the file, CMS is going to start asking questions, and you really want to have your number be as defensible as possible. And really, sort of the best way to do that, at least right now, all the guidance is through an actual formal Medicare set aside.
All right. So, as Brendan was saying, essentially, this whole WCMSA reporting piece that's come into play, CMS's main reasoning behind this, the reason they say they're looking for this information, really is for that coordination of benefits. They want to be coordinating benefits. So, we really are expecting that now that they're able to have this information, and not just traditional Medicare, so parts A and B, but those Medicare Advantage plan, Part C and D plans too, they're going to be expecting to be coordinating benefits against these MSAs now that they have that information. So if we are not reporting things that are accurate, if we're not reporting MSAs appropriately, that's going to create a lot of potential issues for the beneficiaries as that gets looked at and as they continue to treat after settlement. Again, this requirement to report that MSA started in April 4th of 2025. So if we have a settlement that's after that date with a workers' compensation claim with a Medicare beneficiary, there has to be this MSA amount reported. Doesn't matter if the MSA amount is zero, there has to be something in there that is showing there needs to be basically a populated amount for an MSA. I think there was sort of this long time idea in the industry that that $25,000 review threshold for CMS was a safe harbor of sorts, but that's really not the case. If we are settling with someone who's a Medicare beneficiary for less than $25,000, there's still this expectation that we are considering Medicare's interest in that settlement and that we're determining what that set aside should be. So if you're someone who's been doing no MSA in those situations, that is in terms of what we would be reporting to Medicare in that situation would be zero, which ultimately means that Medicare could consider, up to that $25,000 to be the Medicare set aside, which again could create some issues with that coordination of benefits. So absolutely, an MSA has to be reported. Absolutely, I think Medicare is going to be, it's going to result for sure in beneficiaries having denied claims. They haven't sort of talked about this auditing from any other auditing perspective or like identifying bad actors. That's not supposedly something that they're going to be doing here, but it's certainly going to create just a different environment, especially with the Medicare Advantage plans. I think who will be doing, I imagine, just because they tend to be even a little bit more stringent in terms of Medicare compliance, that we'll see denials happening here a lot. And then more unfortunately, and I think a little bit more sort of as they start to do that, particularly with prescriptions, I think that's going to get really dicey. Yeah, so we're always going to report that. And then I'll send it over to Brendan to talk about the actual
Sure.
reporting piece.
So as far as the new fields, right? So CMS now has access to the 7 new data fields in particular. So CMS will now know the Medicare set aside amount, right? That makes sense. CMS will now know the Medicare set aside period, which is typically just the life expectancy of the claimant. So how long the Medicare set aside fund is anticipated to last. CMS will also know how that Medicare set aside is being funded. Is it being funded via an annuity, or is it being funded via a lump sum? If it's being funded by an annuity, Medicare will know the initial deposit amount and the annual deposit amounts thereafter. And then CMS will also know, these fields aren't, I guess, required, but CMS will also know the case control number. At least this is what CMS asked for. So a case control number is a number that's automatically assigned to a file if that workers' compensation Medicare set aside happens to be voluntarily submitted to the federal government for review and approval. So if it has, you just plug in the case control number there, and hopefully, if this is a case where you went through the process of submitting the Medicare set aside to CMS and the settlement's actually finalized, you want to make sure that CMS's final determination amount, the coverage period, whether it's annuitized or lump sum funded, you want to make sure that all that matches in your actual Section 111 reporting, because we have heard of some issues where there's not a direct one-to-one match. And then lastly, CMS also would like to know how the Medicare set aside is being administered. If it's being professionally administered, CMS just requests the tax ID of the professional administration company so they know who's handling the funds. And another important point for all of these fields, if one of these required fields, if the information is not populated, keep in mind that these reporting fields are a subcategory of the entire TPOC. So if there's a required field here, and let's say you don't report the Medicare set aside amount, but you report everything else, it'll actually cause an error in your Section 111 reporting, and it'll be as if you never reported a TPOC in the first place. And so if that's not corrected, and if you don't timely correct that to get the record through, such that the TPOC is reported within that 365-day window, well, then guess what? That opens you up to civil money penalties simply because you forgot or maybe inserted a non-numerical value into the MSA field or any of these other required fields.
Actually, I wanted to chime in quick here to Brendan and Kayla. I think one of the things that we saw with the delay in the implementation of civil money penalties is as a direct result of the implementation of this WCMSA reporting. So there have been a lot of known issues. We've talked about them in prior webinars. We've recorded those webinars. So if you haven't had a chance to watch them, we can certainly get you links if you let us know. But there are very clear issues. Medicare had some, really rigorous coding that relied on matching for these fields that Brendan just went over, and it's caused quite a bit of chaos in terms of matching records with MSAs in particular that had been submitted to CMS. So this is part of the reason why, it is the reason why we are seeing a delay in the imposition of civil money penalties till July 2026. So just wanted to add that in.
All right, so one of our other sort of predictions for 2026 is that we're going to continue to see the increase or rise of the non-submit MSA. We like to include the statistics here to show you essentially what we're seeing year over year as far as how many MSAs are being submitted to CMS for review. If you look, this might be kind of small on your screens, but generally overall, we see a decrease, right? If we look at 2023, we're up close to 16,000 MSAs and continuing to see that decrease down to about just under 14,000 MSAs in 2025. If you look at this and you're wondering why we were seeing that decrease and there was a little blip in 2023, we did sort of historically see CMS had some sort of scared the industry at one point about non-submit MSAs, but they walked that back, understanding that there's really no requirement that any of this be submitted to them for review. It's a voluntary process. You do not have to submit your MSA to CMS to be reviewed. And there's reasons why you might not want to, right? So we know that we continue to see on average a 24% counter hire when we're submitting an MSA to CMS, meaning, for example, if we submitted an MSA for $69,000 or so, on average, they're going to counter high at around $86,000. So essentially, that's just why you may or may not want to submit to CMS, right? There's always going to be that risk of that counter hire, and we know that those counter hires often happen due to, surgeries that we really don't feel are medically necessary, or, CMS is always going to be allocating in the worst case scenario. They want to make sure that they're covered and that, they're not going to, they want the MSA to not run out of funds. They want that MSA to truly last for that natural life expectancy of that individual. But again, ultimately, we need to consider whether or not the MSA is reasonable. It should make sense for the settlement. We don't want to be overinflating these MSAs. And because of that, non-submits just continue to become more popular and more accepted in the industry, I'd say.
So we only have 10 minutes here, so kind of have to get through these next slides. So this next section is all about the updated NGHP user guide. So CMS kind of snuck in an update to the NGHP user guide on January 5th. For those of you out there who are subscribed to receive CMS alerts like me, I was actually not someone who received that alert. So I actually was not aware that it was updated until days later. So we'll talk about kind of what that was. CMS, in their most recent webinar, when they went over civil money penalties, addressed this. They said there was some sort of technical issue, so they apologized that not everyone who was subscribed to receive alerts received notice of the NGHP user guide actually being updated. But before this January update, there was a very meaningful update that occurred in October of 2025, and we'll kind of walk through all the significant language that happened then. But as far as the most recent language to the guide, the only major change was CMS, or not even change, sort of everything staying the same, is CMS is maintaining the $750 reporting threshold for 2026, which I'll let Kayla cover.
Yeah, and I don't think we need to, in the interest of time, right? Essentially, that threshold is remaining the same. If we're settling for $750, we don't need to be reporting those settlements to CMS, and that threshold remains the same for the $750 for recovery. So if a settlement's under $750, CMS is not going to be recovering for conditional payments in those circumstances. So this threshold has been the same now for a good amount of time. So
Yeah.
Hopefully one day they'll shift.
Okay, so we're off the January update. Let's go to the October update, which is pretty meaningful. So CMS, CMS introduced, let's say, a lot of language. Okay, so let's get into it. There's about 4 or 5 new paragraphs of language that CMS added. First paragraph dealt with joint settlements, judgments, awards, or other payments. So I think this one kind of, makes sense. CMS says, quote, in a joint settlement situation, right, where you have multiple defendants, multiple RREs, each RRE must report any responsibility it has for ongoing medicals on a policy by policy basis without regard to the reporting or policy details of any other RRE or co-defendant. I think that makes sense if there's multiple defendants and one claim is maybe denied under a policy, maybe it's outside of the coverage period, but there's a co-defendant, a separate RRE who actually has coverage under their policy, then that carrier would accept ORM, the other carrier would not, right? They're reporting two different things based on what the actual language of their policy says. I think that makes sense. CMS goes on to say, where there are multiple defendants, and they each have their own separate settlements with a plaintiff, the applicable RE reports that separate settlement amount. I think that's pretty fair too, right? Different settlements, different settlement paperwork, whatever carrier A says is going to be different, settles for is going to be different than whatever carrier B settles for. So they're again reporting two different things. But then this language stays the same, which I think was maybe a point of confusion in this, but for a settlement, judgment, award, or other payment with joint and several liability, meaning it's one settlement, there's multiple defendants or REs, and if one defendant, for whatever reason, let's say is insolvent and can't make payment, right? The other defendants in that settlement then incur the responsibility or liability to make payment for that other carrier who can't make payment. So potentially each defendant is potentially liable for up to the total settlement amount itself. In that scenario, all REs in that joint and several liability settlement have to report the total settlement amount rather than just their assigned portion or share.
All right, so the other section in here that's updated is submitting multiple records for a single individual. They basically say if we're going to be submitting multiple TPOCs for the same individual for the same incident, but that's going to be reported by different RREs, that record's going to need to reflect each RRE's unique TPOC amount, right? So in that scenario, multiple TPOCs, but different responsible reporting entities, they're going to be reporting their unique TPOC amount, not the aggregate TPOC. And then if more than one of those responsible reporting entities is assumed responsibility for ongoing medicals, also Medicare would be secondary to each such entity, right? So it's sort of recognizing multiple RREs being responsible for these same dates of injury, and kind of talking about ORM within that as well. So I think pretty straightforward here.
Okay, I think this language caused the most concern in the industry. CMS did a complete 180 here. So brand new language, brand new policy from CMS on how to report settlements with multiple dates of injury for a single claim. So CMS says, quote, where there are multiple incidents, multiple dates of incidents being resolved with one TPOC, the RRE shall report the earliest date of incident and include all diagnosis codes being settled for all dates of incident. This applies regardless of the timing of the subsequent DOIs, the nature of the injuries, or any other allocation made to each date of incident in the settlement documents. This ensures that all medicals that were released by the settlement are accurately recovered, while still affording the beneficiary a dispute and administrative appeal process if any claims are erroneously identified. So yeah, decent amount to take in here. This is a pretty significant update. I don't maybe Annie could comment. I don't necessarily know that CMS is aware of how big of a shift this is, right? Because sort of how things operated historically was uh, when you had a claim or multiple DOIs, each DOI was reported under separate TPOCs. But CMS is saying, hey, no, like you shouldn't do this anymore, right? You have to report these all under one TPOC. And as for the DOI, you need to report the earliest DOI possible. So I'm not sure that many RREs claim systems are kind of set up for this change in policy. I would not be shocked if RREs out there are saying, "Hey, like we quite literally can't achieve this through our reporting software or system, so we're not going to comply." So this could be an issue, just something to keep in mind. I'm not sure if Annie.
Yeah, I do want to jump in here. This is controversial. It is being discussed with the agency by both the National MSP Network and the MARC Coalition. We recognize systems cannot do this in a lot of ways, nor is it advisable when you look at how claims are handled. And data integrity is just, the end all be all for what we all do. And this is, bonkers to just put a label on it. So we only have a couple minutes left, so I'm actually going to kind of advance us on. We have covered some of that in our prior webinars, so please check them out. But with that, I'm going to kind of speed us ahead here just for the sake of time. We do have a webinar coming up here in February. So if you sign up for our webinars, you will be automatically registered for this. Brendan will be featured again. I'll be emceeing, but we'll have Brian Bargender on from Humana, and we'll be talking about data sharing or data scaring. CMS released a new information exchange memo with Part D plans late in the year, and we'll be talking all about kind of what that means in the world of Medicare Advantage plans and particularly Part D plans and coordination of benefits. If you would like to be automatically enrolled in our webinar series, please shoot us an email at spotlight@sandersoncomp.com. We will automatically register you for these. If you're unable to attend, you will receive a copy of the recording itself and slides. So we will get that out to you as well. With that, thank you so much. Brendan and Kayla's contact information are in front of you on the screen. Please email them, call them, and let them know if you have any questions. You can certainly reach out to me or Heather Sanderson as well. On behalf of Heather and our entire firm, thank you so much for attending our first 2026 webinar, and we hope to see you throughout the year. Thanks, everyone. Bye-bye.
Thanks, everyone.